Welcome to today's Explainer. We're diving straight into something that, let's be real, strikes absolute terror into the heart of anyone running a business: a broken promise. You know the drill. You shake hands, you sign on the dotted line, everyone's happy, and then nothing. The other side totally drops the ball. The immediate reaction? Usually sheer panic and a lot of stress about your bottom line. But hey, don't worry, because today we're going to untangle this entire mess together.
Okay, to really wrap our heads around this, let's anchor it to a real-world scenario. Picture this. You're a retailer right here in Lenexa. You've got this massive blowout weekend sale coming up. Your shelves are prepped, your marketing is out, and the supplier you hired just never shows up. Zero inventory. Your customers are going to be furious, and you are literally left holding the bag. It's an incredibly stressful spot to be in, right? Your business is suddenly on the line, and you need to know right then and there what your actual options are.
So, here's our game plan for this explainer. We'll quickly run through 1. When business contracts break down, 2. Identifying the types of breaches, 3. The true costs involved, 4. Proving a breach, 5. Why mediation beats court, and finally, 6. The exact steps to resolve the issue.
All right, let's jump right into Section 1, when business contracts break down.
Look, at the end of the day, contracts are basically just built on trust. They exist so everyone knows exactly what's expected of them. But when that trust fractures, well, let's cut through the legalese for a second. A breach of contract simply means one side didn't fulfill their legally binding agreement without a really good, valid reason. But here is the absolutely crucial foundation. Before you can even claim a breach happened, you have to prove you had a rock-solid contract in the first place. We're talking an offer, an acceptance of that offer, an exchange of something valuable, and a clear mutual agreement on the rules. No contract, no breach. It's as simple as that.
And honestly, on the ground for local business owners, a breach usually isn't some dramatic corporate espionage out of a movie. It's the everyday, highly annoying stuff. We're talking about a client totally ghosting you on an invoice, or maybe a contractor doing subpar work that completely misses the mark on a renovation spec, or, a supplier missing a vital deadline that completely throws a wrench in your entire schedule.
Moving on to Section 2, identifying types of breaches.
So, when things go sideways, deadlines are missed, payments are dropped, you've got to understand that the law doesn't treat every breach the exact same way. It's all about severity. Think of it like this, using a classic example from our sources. Say you hire an agency to build your company website. If they take your money and literally never build the site, that is a material breach. It's a massive violation that completely ruins the core purpose of the deal. In that scenario, you can scrap the contract and sue. But what if they deliver a stunning, perfectly functioning website, but they hand it over just one day late? That's a minor breach. The main job got done. The contract stands, though, sure, you can still seek some compensation if that single day actually cost you money.
Now, the timing of a broken promise is super fascinating. An actual breach happens right at, or maybe just after, the deadline. The clock strikes midnight on day 0, and the work just isn't there. But think about this. An anticipatory breach, lawyers call it repudiation, happens when the other party straight up tells you ahead of time, let's say 7 days early, that they aren't going to pull through. And the huge takeaway here? If they actually declare they're going to bail early, you don't have to just sit around waiting for disaster. You are legally allowed to take action and protect your business before that deadline even hits.
That brings us to Section 3, the true costs involved.
We got to get a bit serious for a second here, because when these agreements fall apart, the financial toll can be devastating. It is way more than just an inconvenience. When courts try to fix these messes, they usually look at 3 types of financial penalties. The vast majority of the time, they focus on compensatory damages. This is just money meant to cover your direct, immediate losses, basically putting you back exactly where you started. Then you've got consequential damages. Those cover the ripple effects, the indirect losses, like lost future profits because he didn't have the inventory to sell. And finally, punitive damages. Now, these are super rare, just a tiny sliver of cases, and they're only used to severely punish someone for doing something exceptionally wrong, not just for breaking a standard rule.
But listen, the money? That's only half the story. The real, hidden cost of a bitter, dragged-out legal fight is the total destruction of your business relationships and your reputation. You know how it is in the business world. News spreads like wildfire. The trust you lose during a nasty, public fight almost always ends up costing your company way more in the long run than whatever that initial broken contract was worth.
All right, Section 4, proving a contract breach.
So, say the relationship totally breaks down and you're heading toward a full-blown lawsuit. The stakes are incredibly high now, and the legal hurdles, they are strict. You can't just storm into a courtroom and yell that someone was unfair to you. You absolutely must hit every single point on this legal checklist. Miss one, and your whole case falls apart. First, you have to prove that a valid contract actually existed. Second, you have to prove that you actually did your job perfectly. Third, you prove the other guy totally failed to do theirs. And lastly, you have to prove their failure caused you real, quantifiable financial damage. You basically need to become a document hoarder for this. Save every single email, text, invoice, and receipt. In court, your word means nothing without a solid paper trail.
Okay, let's pivot to Section 5, Why Mediation Beats Court.
Honestly, this is my absolute favorite part of today's explainer, because I have great news. You literally do not have to subject yourself to the misery and expense of a lawsuit. There is a much better way. Just think about this quote directly from our sources. Mediation lets both sides find a fair answer. People can skip a long legal fight. Seriously, if you're a business owner currently having nightmares about stepping foot in a courtroom, that should be a massive sigh of relief.
Just look at the night and day difference between these two paths. Litigation? It's wildly expensive, it drags on for months or even years, all your dirty laundry becomes public record, and some judge completely out of the loop dictates your fate. But mediation? It's significantly cheaper. We're talking resolution in hours or days, not years. It's 100% confidential, so your reputation stays totally safe. And the absolute best part? The neutral mediator doesn't just hand down a ruling, they actually help you and the other side talk it out, meaning you keep control and you decide the final outcome together.
To really see the magic of this, let's loop back to our earlier story, the Lenexa retailer and the no-show supplier. Instead of suing each other into total oblivion, they brought in a mediator. They sat down, stopped pointing fingers, and actually found a win-win. The supplier explained they had some crazy logistical hurdles, so they got a timeline extension. And in return, the retailer got a short-term financial credit, which totally saved their cash flow while they waited. Boom. They saved their business relationship and even went on to do more projects together. That right there is the pure power of mediation.
Which brings us to our final part, Section 6, Steps to Resolve the Issue.
We're in the home stretch now, and I want you to walk away with clear, actionable steps the second a contract starts getting shaky. Honestly, you might want to mental screenshot this roadmap. If a breach happens, step 1, resist the urge to immediately point fingers or send an angry email. Take a breath, pull out the actual written contract, and identify the exact technical issue. Step 2, gather up all your documentation, emails, notices, the whole shebang. And step 3, before you even think about dialing a lawyer to file a suit, reach out and partner with a skilled, neutral mediator to get a real conversation going.
So I'm going to leave you with this one final, provocative question. Is your business truly prepared to handle its next big dispute without completely burning bridges? Look, by understanding your contracts inside and out, keeping impeccable records, and fully embracing mediation over a nasty court battle, you protect so much more than just your bottom line. You protect your invaluable business relationships. Thank you so much for hanging out with me on this explainer. Next time a business dispute pops up, I challenge you to look at it not as a guaranteed lawsuit, but as a real opportunity for a mediated conversation.